Okay, we'll make a start and anybody that's joining can continue. So welcome today to HR Recruit's virtual mock tribunal, which is being run by Vista Employer Services. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Vicky Roberts and Stephen Foster. They're going to provide a real insight into how a remote hearing is run, how decisions are made and how actions taken can very easily become key features of a tribunal hearing. During the session, there will be the opportunity for you to ask questions using the chat box facility. I'm now going to ask Vicky and Stephen to introduce themselves and say a few words about the structure of the event.
Thank you, Jo, and it's an absolute pleasure to be joining you. My name's Vicky Roberts. I'm one of the lawyers in the team and I head up the learning side of the Vista business, and I'll hand to Stephen to let him introduce himself to you.
Thank you, Vicky. Yes, Stephen Foster. I head up the legal team at Vista Employer Services, and I've been to many tribunals. I won't give you how many years, but yes, I'd like to share some of that experience and hopefully pass some top tips across today. And feel free to ask any questions that you like.
Lovely. Thanks, Stephen. Super. So the plan for today then, we're going to have a look at the claim that's been raised by Agnieszka Czosowska against her employer and her manager, and Stephen has the delightful job of playing the role of the manager today. So we're going to give you as realistic as we can experience of the on the day in a virtual tribunal hearing. They've been running now for a couple of years, started sort of very soon after the pandemic hit us all squarely between the eyes. And by all accounts, it's going to continue that way. It certainly seems that the tribunal service considers it to be an efficient way of running many of the hearings. So Stephen, as well as his many years of face-to-face hearings experience, has also got the CVP, the Cloud Virtual Platform version under his belt now, and is going to share some insights in terms of what that process looks like. And we'll do it in the context of this fictional, but based on our experiences, case study. As you know, with all tribunal hearings, witness statements are taken as read. So when I started practicing, it was the case that the claimant and the witnesses read their witness statement to the tribunal. That doesn't happen anymore, hasn't done for a number of years, as I'm sure many of our audience know. But you've had the opportunity to read the witness statements through the virtual bundle that we shared, or Jo shared as part of your attendance at this event. If you haven't had a chance to have a look at it, don't worry. We're going to summarize the case in a moment, give you the kind of basic facts of it. And what we will see is the cross-examinations in action. Because the case is quite involved, it's a case of direct race discrimination and of harassment. We're going to break this cross-examination down into its constituent parts and sort of explore some of the issues that are coming out. Why has the cross-examination gone in the direction it has? How do we feel that the cross-examination has gone from the parties' perspectives? And that's the opportunity. Please feel free to ask questions on the chat as we go. Stephen and I will both be keeping an eye on it. So we'll take your observations as we go along and any questions. Also, we're going to give you the opportunity to give us your views in the form of a Mentimeter poll about who do we think is going to win in terms of the various cases, and we'll run that 3 times to see whether views change as the case progresses. That roller coaster ride that I know some of you will be familiar with as the case progresses throughout the hearing. Now, we're together until 4:30. It's not going to be a straight run. We will take a short break in the middle of it just to give you a chance to stretch your legs and check phones and emails and what have you as we go through. We'll, as I say, I'll take a break. And at the end of the session, it's decision time. And we will ask you to help us with the closing submissions, which will help me make my decision, because I've got the unenviable job of being the employment judge for this afternoon. And so we will see how the feedback comes through. I've just seen a note to say the sound's poor. I'm so sorry. Oh, it's fine for some. Okay, well, we'll persevere. Thank you for those of you adding comments. Oh, lovely, super. Thank you for all the comments as we go. In terms of, I just also saw a question on the chat about having to take a break in the middle of the session. Yes, the recording is going to be shared of this as well. So if you miss sections, you can go in and see the bit you missed, certainly as well. Okay, so let's take a little look at the case, Stephen, shall we, first of all? Talk me through the key issues, could you please?
Yeah, I think the key issue here is that this is an everyday management situation. The business manager, James Fletcher, believes that he's made an appropriate decision, which is fair, and it's a business decision which he thinks is in the best interest of the individual and the business. The claimant's position is quite different in that she has made the allegation that she's been put into a particular position, and she has linked this through not necessarily to her ethnicity herself, but her ancestry, which is quite an interesting approach. But what she's saying is that she has suffered less favorable treatment because of that treatment, and that's in a nutshell, really. This is often a situation that you find is that these decisions are made for the best interest of everybody, and it's often the communication of that and where we as managers and HR professionals can learn how we can improve those and avoid assumptions being made. I often describe it as individuals look at things through their own particular lens, and once they have something in their mind, they associate that happening to that lens that they're looking through, and this is one of those cases. And for that reason, the manager now has to explain the reasons behind the decision. So that sums up both sides of the case in a non-legalistic way, I hope.
Absolutely. And there is also a harassment complaint as well, isn't there?
Yes. So harassment, I always describe harassment as it's often defined by everybody, but in non-legal terms, again, it's an act which affects somebody's dignity. And I think the key there, the bit that everybody misses, is the intention is irrelevant. It's a case of how it's perceived by the individual, not how it was intended to be perceived. And that makes it a slightly different test for individuals. So harassment is one of those things which be alert to all the time. And often you see so many cases, well, that's not what I meant. This is how I put it across, or this is what I did. It doesn't matter. It's the perception. It's the point of view that you need to take into account on harassment allegations.
Absolutely, absolutely. So the nature of the management decision then, for those that haven't had a chance to have a read at the bundle, was an allocation to manage a particular aspect of the business. And the claimant is saying Agnieszka, Agnes as she's known, and she's accepted that people can refer to her as Agnes, was allocated the Polish market based on her heritage. So there's that direct link in that sense. And she's saying that that's detrimental to her because, of course, direct discrimination needs to be less favourable treatment, doesn't it? So why is she saying that allocation is detrimental to her then, Stephen?
Well, what it is that this is a sales force which is target driven. And what she's saying is that having been moved to that particular area, she has suffered in that she will have a more difficult time to achieve, ability to achieve those targets. So that's the detriment, that's the less favourable treatment that she's received. The manager's position is that he feels that she is best placed because it's a new market. So he's got his reasons, and you'll see as this case and you hear the evidence without wishing to spoil things, you'll hear the evidence as to that justification, and it'd be interesting to see as individuals how you feel this pans out, because remember, judges are humans, so put the law to one side, go with what you feel is appropriate and whether there's any lessons to be learned there, if any.
Absolutely right. Lovely. Okay, thank you, Stephen. So let me start with taking a quick poll for those who have had chance to have a read at the paperwork. What you will have seen in the pre hearing bundle, and remember, as normal, these things are exchanged in advance. So you'll have seen the witness statement of the claimant, Agnieszka, and of James, who is the manager. Stephen is playing James today, and he is also a respondent in his own right. So Agnieszka has brought her claim against her employer and against James Fletcher, her manager, personally. Why, Stephen? Why?
In simple terms, is that the business has the overriding obligation to the employees. So, but more importantly, from the claimant's perspective, they're more likely to have the deeper pockets for any compensation. In terms of tactics, individuals are often included because it applies pressure. Often that individual feels a lot more stressed and a lot more defensive, and that sometimes encourages settlement at an increased figure. So very often it's tactical, but ultimately there's 2 points to note. In most cases, the employer and the individual will work together. Another reason that you may separate out the individual and the company is that the company may have a defense that it took all reasonable steps, and it may effectively hang the employee out to dry. So if the individual's been trained, been warned, and is still being discriminatory, then the tribunal might find in favour of the company and say, well, fine, the employer did everything reasonable, and it may be that the individual is liable. But in most cases, you would sue the employer and the individual.
Yes. So for the purposes of this case, the respondent, the employer, Randolph and Tanner, has decided to run its defence alongside that of James Fletcher's. So it's the same respondent team. If it were to be separate, then you would see three parties effectively. So you would have three lots of representatives in that sense. And so it would feel slightly different. And as Stephen says, it's a decision that's made often by employers based on the extent to which they could run that reasonable steps defence. But for the purposes of today, work on the basis that the employer has decided to adopt Mr. Fletcher's defence alongside his own. Okay, so perfect. So that gives us a bit of an overview. Appreciate not the full detail for those of you who haven't had a chance to have a look at it yet, but for those of you that have, we'd be really interested in your views. So I'm going to share my screen in just a moment with a tool called Mentimeter. You may be very familiar with it. It's a polling tool. So if you have your mobiles at the ready, I'm going to share my screen and show you a QR code. And there's a couple of questions that we would like you to answer for us. First of all, will Agnes win her direct discrimination claim? And secondly, will she win her harassment claim based on what you've read so far? So obviously not having had the benefit of any sort of cross-examination as yet. So what will be appearing any moment now is the voting instructions. So you can either go in on your browser to menti.com and then enter that code, or you can use the QR code, entirely up to you. I'll give you a few minutes to just do that. And let me just share my screen in terms of the voting now. Then let's see. Oh, we've got a nice spread at the moment. Is it settling? Seems to be, doesn't it? Okay. Yes. So small majority in the favour of yes, that she will win her direct discrimination claim. So this was the point about the allocation of the project. Let's move us on then to the still coming in. Don't want to miss anybody. Let us move us on to the harassment complaint then next. stronger view on this one,
Mhm.
Stephen, don't you think?
Yeah, that's interesting. That much clearer view.
Positive amount of jostling around the nose.
Well, that's much more definite, isn't it? Much clearer.
Definitely,
Yeah,
definitely. Yeah. Okay. We'll ask you this a couple more times as the case progresses to see if there is a difference in view as the evidence comes out. Perfect. Okay, let me stop us there. Apologies if people are only just getting to vote. There's one or two still coming in, but I don't think it's going to change the overall mix. Super. Okay, so let's get to some thoughts about on the day then, Stephen, shall we? So this is a CVP hearing, as it's called, virtual hearing.
Yes.
Talk me through what's the same compared to sort of face-to-face training, face-to-face tribunal hearings, based on your experience.
I think that's a good starting point. I think anybody that's been to a tribunal, the good news is it's almost identical, and it's a good starting point. So the process, the procedures, those attending, you'll still have the tribunal sitting on it, a judge sitting on their own if it's an unfair dismissal. In discrimination cases, you'll have a panel, and the order of the witnesses is the same, and the evidence. So as you mentioned earlier, Vicky, the evidence in chief, which is your statement, is taken as read, and you go straight into cross-examination. So everything along those lines is exactly the same. I think what's worth pointing out is the biggest change is that tribunals themselves can be tiring. But what we've noticed, and the tribunal judges themselves have also expressed, is that tribunals by CVP are far more tiring. It's just the way that we operate, and I believe there's some psychology to this, is that we're trying to read body language that we can't see. We're not picking up the same signals, and therefore the brains are working harder. But whatever the reasoning behind it, it's definitely true that remote hearings can be more tiring. There will often be a few more breaks. But that's the biggest difference. It's the brain power that it takes. Procedure-wise, very, very similar. But there are some top tips that we can give in preparation for that, if that would be helpful.
Please do.
The first thing to do is, as you've seen today, there's always IT issues. The judges have become quite used to that. They're very calm, very placid about it. There's no rush. They will wait for people to turn up. But the most important thing is it's at least 2 days, and that does seem very tight. And some tribunals, or even the night before, will send a link to join the hearing. But at least a week before that, the actual hearing, they will have sent a guide and a test link. And it's extremely important that you do try that. The first thing to do is make sure you've got a laptop, iPads possibly, but do not try and do a tribunal on your mobile or just a mini iPad or whatever. You will be looking at documents, so make sure you've got a computer screen of some decent size. Privacy is another thing. Often judges are very, very tolerant, but they don't want people walking around in the background. You treat it as a courtroom, so make sure that you've got a room where the door is. Do not enter. It sounds very obvious, but you'll be surprised how many tribunals that people do have disturbances. Judges don't like that. They don't tolerate that. They don't want people sitting around. Some judges in the early days were actually asking you to pick up the remote and show the room to make sure that you didn't have anybody guiding you, and to make sure that you had a clean copy of the bundle. Make sure you've got a copy of your own documents. You want 2 copies of the bundle. You want the copy that you write on, you do all your post-its on, same as you would at tribunal, but make sure you have a clean copy. Even though you're not present in the tribunal room, make sure you're complying with the rules. Judges will go, they'll go in quite firm on individuals if they believe that that's not being followed. Half of them should check, but when they do, don't be the one that calls out. The other thing I think you need to do is taking the oath, or whether you're affirming. It's one of those things that's often overlooked. Now, if you're present at a tribunal, it's much easier. They'll run around in the tribunal to get the appropriate book if that's the chosen course. But if you're remote, make sure that you've got whatever the relevant holy text is to hand. And make sure you do that in good time. Some tribunals, it sounds like a minor point, but some tribunals will not commence. If you say that you wish to swear on a particular holy book, they will not commence until the right book is there. So again, it's one of those things that's often overlooked. Dial in details, make sure you've got the contact details for your representative, your colleagues, and the tribunal clerk. They will wait, they will be patient, as long as you're making every effort to let them know that you are in the process of trying to resolve some IT issues. Don't panic, don't be trying to find those details on the morning. And then the final thing in relation to preparation is communication. Make sure you've got a separate means of communication with your representative in the group. And when you do that, make sure that you go offline. So you turn the camera and the microphone off, particularly in the early days, but even more recently, it's very easy for people to start communicating, think that the judge is gone, start chatting, and you've got the representative on the other side listening in. So in preparation, I would say that those are the top tips. Test, appropriate equipment, location, holy book, and communication channels, and test those before you attend the hearing.
We thought it was complicated in the old days when we were saying to people, make sure you had change for the car park that was nearest to the hearing, didn't we? Now,
absolutely.
Oh my goodness me.
Yeah, there's keys and everything
so much
else.
more to think about. Yeah, absolutely. And I think, I think we've done an awful lot of learning about working digitally, haven't we, over the last couple of years? That your point about, the judge sees everything, and of course your head and shoulders are that bit more magnified, aren't they, when there's only a few of you. And so if you start looking distracted, or like I've just done here, looked to a second screen, it looks as if you're looking into the middle distance. You're not, in fact, but actually just be very aware of that sort of thing, so that you look like you're paying attention and you're not distracting the judge when they're meant to be listening to the cross-examination, thinking, why is she looking over there? Because as you say, we are human, aren't we, in that respect?
Absolutely. Even looking down at the phone, it shows disengagement, and it means that you're not taking the proceedings seriously. And again, judges, for all their good qualities, they believe that are important, and therefore they will take that all into account. Shaking your head, tutting. You wouldn't do that in tribunal, so you shouldn't do it in the exaggerated format. The other thing that we often get asked is dress code. Just because you're feeling relaxed, that you're in your own environment, remember it is a formal hearing. It is a courtroom. So dress as you would if you were to turn up in person. But body language is one of those things. People forget to turn the cameras off and then start taking text and so forth. So yes, a very good point. But
you can still have your tracksuit bottoms on the bottom half. It's just the top half you need to focus on.
You can do the BBC look. Absolutely, yes.
Brilliant. Okay, thank you, Stephen. That's really helpful. Okay, so that hopefully gets us mentally in the zone, as in, we're just ready for this hearing. So as this is a discrimination claim, the claimant will go first. For those of you that are used to an unfair dismissal claim, you know that the respondent goes first in that situation. So what will happen is that the claimant will give her evidence first. And as I said, back in the day, it would be the case that she would have read out her witness statement, but it's what's called taken as read now. So the first thing that we will see is her being cross-examined by the respondent's representative, who is one of our colleagues called Chris, in the recording I'm just about to show you. What you won't see is Agnieszka being taken to give the oath or affirm, but that would be as you would perhaps be have experienced previously, where she'll be asked whether she'd like to give the oath or affirm, and she'll be asked to read out that she confirms that the evidence is true to the best of her knowledge and belief, and that she will tell the truth. That's the same as would normally happen. So imagine what's happened here, therefore, is that she has been invited to the stand. Of course, it isn't a witness stand. It's just she's been asked to give her evidence. She's confirmed that her witness statement that's in front of her is hers, that she's confirmed her address, she's given her oath, and then she's handed over, as it were, to the respondent's advocate in order to cross-examine her. And that's what we're going to see now. Now, we'll see the cross-examination in 3 different sections, and we're going to pause after each one to give you the opportunity either to ask questions or make observations. So we're going to see the cross-examination of the direct discrimination allegation in two parts. So the first thing that Chris will deal with as he cross-examines Agnes is the allegation that the selection is due to her Polish heritage, that causal connection that she has made, because that is disputed. It obviously has to be addressed in cross-examination. So we'll have a look at that first, and then we'll stop. And then we'll go on and look at the aspect of the direct discrimination claim, which is that selection was adverse to her. It was unfavourable treatment. So let's look at that causal connection first.
Can I just make a point there, Vicky? You've made the very important point there as to the causation and the link. Some of you who've been to tribunals might remember that in unfair dismissal cases, it's for the employer to prove the fair reason and that they followed a fair procedure. In discrimination, the burden of proof and the order is slightly different. And this is why Vicky's made it quite clear as to what the points are. The claimant has to prove that there is a reasonable case and reasonable belief for that in order for the burden to shift to the employer. If they don't do that, then they're unlikely to succeed on discrimination. Only when they've given that evidence is it then for the employer to say, actually, that's not the reason for the treatment. So that's why this is a reverse burden to the norm if you've been to an unfair dismissal hearing. So hopefully that just clarifies the order. Sorry.
Thank you, Stephen. Thank you.
Okay, good afternoon, Ms. Trzaskowska. Now, the tribunal's given me some limited time to cross-examine you, so let me get straight to the questions, if I may. It was part of your role to develop new work, and that would involve you being working closely with new clients. Is that right?
Yes, but I wasn't ever given responsibility for developing new markets.
No.
That was something new that was put to me.
But as in your role as business development, it would be quite usual for a business developer to be involved in developing new markets and dealing with new clients, wouldn't it?
According to their experience, yes.
Not according to your own experience. You would never, as a business developer, deal with new clients?
Yes, you would.
And it just dealing with the issue in isolation, just apart from your complaint, it would, let me check, it would therefore be quite normal for you, or let me say for a business developer, perhaps another member of your team or yourself, to be asked to deal with new clients as part of your role.
Yes, to deal with new clients as part of the role, but there is a difference when you're being asked to go into a completely untapped market.
But again, it would be normal for you or one of your team to be asked to go into a new market, because surely that's the goal of your business, to enter into as many new markets as possible. Is that right?
We do, but I would always take a view that if it was a completely untapped market and somebody hasn't, the business hasn't worked in that market before, and neither have I, that we would be doing that with some caution. There would either be somebody assisting or supporting with that, or that my targets would be adjusted to recognise that.
Well, let's break that down. To go into a new market then involves a business who wishes to succeed to play their best player into that new opportunity. Would you agree?
And that's what I would believe to be the case, but I don't believe that was necessarily the case in this instance.
We'll come to your belief and motivation in a moment, but do you agree with that premise that a business who wishes to succeed in a new market surely would play their best player in to try and succeed? Would you agree with that suggestion?
They should.
Yeah, that's good enough. You take issue, though, in relation to the motivation for your selection, though, don't you?
Mm-hmm. Because when you've just said there about the best player, I don't perceive that I would be the best player for an untapped market in that sense. But what I have a sense of is that the reason why I was being put forward as the player for that market was a perception about my nationality.
Yeah, but let me break that down then further. You may agree or disagree as to whether you felt you were the best player. But leaving aside the point that we'll come to on nationality, do you feel that your manager, wanting to succeed, believed you were the best player for the reasons that we'll come to? But do you believe that he was placing you in that opportunity because he thought you were the best player?
He thought I was the best player because he thought I would go in there and speak the language. That's what he thought.
And we'll come to that, but isn't being told that you're the best person to carry out a job, isn't that an endorsement of you? Isn't that a compliment of you?
It is, if the endorsement is about your actual skills, and this wasn't. This was about whether I was going to speak Polish or not.
Well, how do you know that? How do you know that it wasn't a combination of factors?
Because he doesn't realise that, you know, I don't speak fluent Polish, but he just made an assumption on that basis. I haven't dealt with Polish markets previously. It's an untapped market. We don't really know that much about it. It's not the kind of thing that I have done from scratch before. So I would have expected that if he wanted to give me that opportunity to try and develop me and try and aid my career progression, then I would have thought that perhaps he would have given me some support in doing that, which I didn't get. And, you know, I just would have thought that some difference would have been made to my targets as well, because how can you expect someone to meet the normal targets when it's a challenge that they haven't faced before?
You raised several issues there. Let me take them one at a time. Were you told by your manager that the new business would require you to speak in Polish only?
No, he didn't say that.
So we were talking about assumptions being made along the line here. You assumed, therefore, that you'd have to speak in fluent Polish.
I could not see any other reason why he wanted to put me into that position.
Yeah, but the question I asked was, and tell me if I'm right or wrong, without being told that you have to speak in fluent Polish, you assumed that you would have to.
That's the only reason I can think of for him giving me that work to do.
I think we're agreeing on that, but feel free to tell me if I'm incorrect. We also, can we agree that you assumed that there would be a negative impact on you being able to reach your target without actually trying to reach the target? Again, that's correct, isn't it?
It's pretty common knowledge that if you give somebody a difficult, untapped market to go and deal with, it's pretty obvious that you are not going to fly with that from the off. You know, it's going to be challenging. It's going to take time, and you know, having the same targets to meet to do that, that's just not fair.
Well, it's not fair if you are not able to meet the target, perhaps, and you don't have them adjusted. But looking at the assumptions here, you assume that you won't be able to reach target, and you assume that that will be a difficult market. And you must assume that because you have told the tribunal that you didn't know a lot about this market. So those were your assumptions, weren't they?
And that's exactly what I found. I found it to be a challenging market when I was doing the work.
But we're looking here at the motivation and the way you take issue with you being selected. We're agreeing that there is an attempt by the business, at least in principle, to identify and play in the best player. But then looking at the motivation, you say it was less favourable treatment for you to be played into that new opportunity because your Polish heritage. Is that right?
Because the assumption was made that I would just go into that and be able to deal with it all because of my background.
Okay, so that's our first section, picking up with on the points that Stephen was making just before we saw it, which is to say that it's the claimant's job to put forward facts from which the tribunal could reach the conclusion that there was a link to the decision to allocate her the Polish market based on her heritage or ethnicity, nationality. You know, the definition of race in the Equality Act is broad enough to cover all of those requirements. Thoughts or questions on that point? First of all, please feel free to put them forward in the chat. An interesting point here. Is there any info on her previous performance? Stephen, why would that be relevant?
The reason for that relevance is that I think the claimant's own language was there. She couldn't see any other reason. So that went to that goggles or the lens that the individual looks through from their perspective. If there were performance issues, this is where cases often arise. Somebody's being managed and they often allege that they're being discriminated, treated less favorably, bullied even, or even harassed just through pure management. Now, the management can be good, it can be bad, but it doesn't necessarily mean that that was the discrimination or harassment. So that's an important distinction. If the individual here has identified that there may have been performance issues that could explain why we were managing and moving that individual, that may explain the decision taken by the business and may mean that it was nothing to do with ethnicity. So it's a very good question, that, and I won't spoil the answer.
No, quite so. We'll come to that in just a minute. Lovely. A really interesting point here. Agnes kept making the point that it was an untapped market, but isn't that an assumption?
Yeah, and you will see that Chris, the advocate there, was very, very clear on that, is that that's the strongest point. It was assumptions, and we're trying to prove that actually there may have been good business reason. You've linked these things. That's not the business's decision. That was your decision or your explanation for it. So it's a subtle way of proving that actually you may believe that, but it doesn't mean it's right.
That's it, trying to break.
Yeah, and the only other point I was going to make, you often hear this in discrimination cases where is the person doesn't feel it was fair. But fairness, again, lack of fairness does not mean it was discriminatory.
No.
Even bad decisions can mean they're bad decisions, but it doesn't mean that they were discrimination. It's got to be linked to the protected characteristic. It
doesn't make for a great defence, that said, does it? Yeah,
no,
but
it's we've escaped on
right.
That. Yes, we have escaped on that. So it's not the best of defences, but if that's all you've got, it's better to be open about it and say, look, bad decision, but not related to the protected characteristic.
That's it, exactly. And it's all about a manager showing their workings, isn't it? What is the reasoning behind the decision in order to be able to defend the claim if what Agnes has done is enough to shift the burden to say, right, now it's your job, employer, to prove the absence of discrimination. And the test is high here, isn't it? And once that burden is shifted, it's a high burden, isn't it, for the employer to respond?
It is. And I think that burden just become higher in relation to certain elements of discrimination claims where it's not too hard for them to clear the first burden. But again, the harder element for them is to actually prove that it was linked to the protected characteristics. So focus on that. Was there a decision? What was the reason for that? Can we prove it? And if you can do that, then you're halfway home.
Yeah.
Important point I've just seen on the chat there was what was the discussion? What was the discussion? And that is, again, another fundamental point. In most cases, whether the unfair dismissals, protected disclosures, it's the lack of communication that allows the individual to come to the assumptions that they do. But sometimes those assumptions can carry weight. And now, as you see in this case, it may have been an assumption, but now it's on the burden shifted to the employer to prove otherwise.
Yes, absolutely right. And so often we see tribunal hearings with, lever arch files full of paperwork.
Yes.
But as we've got here, a case without any bundle at all, really, other than the witness statements, no documents at all, which doesn't help us in terms of the quality of the discussion that was had. And there's some really good questions here that would be absolutely key to the preparation of this. Did she ask for support? Did she have the opportunity to turn this down? What did she say? All of those things that are relevant to that conversation. But it all does go back to the link between the reasoning, the decision making of Mr. Fletcher, the manager, as to why he had selected her. And if this is in fact less favourable treatment, which is the bit that we want to go on and have a look at next. Why is it, in Agnes's view, less favourable treatment? Yeah. So let's go on and have a look at that in a moment.
If we move on then to the second allegation that you raise, you state that you were offended.
Apologies, just jumped on one too many. Bear with me just a moment.
So it is the assumption that your Polish heritage might give you an advantage in a sales environment.
Yeah, that's the assumption that was made, and that's why that's why they didn't adjust my targets, because they thought it would keep up there with it.
Leaving the target issue aside, in relation to the motivation to place you in the role, I think we've agreed that the motivation is to play in your best player, which I say is an endorsement. And then the motivation is also to identify something in a sales environment that will give you an advantage to allow you to further succeed. So again, isn't it positive and favorable to allow you potentially to take advantage of commonality with a new client?
But doesn't that conflict with what James actually said to me? Because he suddenly mentioned to me about some issues with my communication. So if he thought there was issues with my communication, how does that make me a best player to build rapport with a new client?
Well, do answer my question though, because I'm putting a principle to you and you're giving evidence about something else here. So my question to you is, isn't it advantageous? It occurs to me that it would be, to allow you to play into an advantage in a sales environment, that being the commonality of heritage with a otherwise cold or new relationship. That's the principle I'm putting to you. Do you agree with that principle in sales or
no,
not?
I don't. No, I don't, because my background, I don't know anything about that market.
Do you know anything about sales?
I do know about sales, but there's no advantage from my background to that. There was no advantage from my background to that.
Well, let me put that to you then. In a sales environment, I'm a lawyer. I'm not a salesman. So I look to those who are better salesmen than me. And I look to the Harvard Business School, the Harvard Business Review, that examines the key recipes for success of salesmen. And I can glean just from looking at the basic sales concepts and environments that having synergy, having empathy, having commonality, having shared interests are very clear advantages in a sales environment. So again, going back to the premise that
I didn't have any of those shared interests or commonalities at all.
Well, if you're speaking to somebody in Poland and you have a Polish heritage, would that give you, and correct me if I'm wrong, would that give you any commonality or ability to discuss any shared interests? It wouldn't.
No, I haven't lived in Poland. I don't believe it would give any commonality there at all. I haven't lived in Poland, and James made an assumption that I would have all of these things about the culture baked into me just because of my name.
And what, just explain to the tribunal then your heritage. What's the heritage of your parents?
My parents are both Polish.
So how much do you know about Polish culture, would you say?
Not a huge amount.
Your parents didn't teach you about Polish culture?
I was born in England. I was raised in England. My parents did their best to fit in to England. And so we didn't speak Polish at home. There was just little bits of it that I picked up here and there. But my father was adamant that, you know, when in Rome, you do as the Romans do. And so I was brought up in England, and I consider myself to be a British citizen, and I do not know much more about Polish culture than many other people.
No, nobody's questioning your citizenship here. We're just looking to establish whether you had an advantage due to heritage, whether that advantage was slight, whether that advantage was great. We wouldn't be able to establish that over somebody who didn't have your heritage. So looking at that, are you saying that your parents didn't teach you anything about Polish culture that might give you an advantage in speaking to people who are Polish?
No more than what some other people may pick up around Poland. There may be other people who have had holidays in Poland, who have absorbed themselves in other types of Polish culture that would know more than I do.
Well, what I would suggest to you is that your manager is playing in his best player. It's an endorsement of you. It's a compliment of you. And you're distancing yourself, I would suggest, from the fact that you would have an advantage due to your Polish culture in a Polish sales environment. It would have offered you better synergy, empathy, commonality, and you're distancing yourself from that for the purposes of saying to this tribunal that you were treated less favourably and are so offended by that. What do you say to that?
I am offended by that. He's made an assumption about me just based on my name. He knows nothing about my background. He doesn't know how much I know about Polish culture. He never asked me. He never took the time to find out. And the very fact that he said to me, there have been issues with my communication, which had never been raised before, just makes me then believe that that is exactly the assumption that he'd made.
But he actually tells you, so looking at motivation, he actually tells you that he thought that you would be the best person to undertake and succeed in the role, doesn't he?
Because of my communication.
Well, he actually tells you also in his evidence, the combination of your statement is that he thought that you would be the best person to do it. And his evidence actually accepts that it was the cultural advantage that you might have. So he's trying to give you and let you play into an advantage over others. Isn't that more favourable treatment on the face of it?
No, he made an assumption on something that he didn't actually know about. He never asked me. He never checked that.
So there we have it.
Lots of debate going on in the chat there, wasn't it?
Isn't there just? Yeah. Let's pick up this really interesting point about the might her name come from the fact that she's married? May it be that she isn't actually Polish? From a technical perspective, of course, you can still be discriminated against on the basis of a perception.
Yes.
So if somebody's treated unfavorably based on the perception of, in this case, their ethnic background or their nationality or their race, then that would still fall within that technical definition, of course, of race discrimination.
Yeah.
Which hopefully picks up one or two of the points about how did he even know. So even if he was wrong in his perception, if he was linking his decision to selecting her to a perception of her Polish background, then if that decision is unfavorable, then that definition of direct discrimination can be made out.
It's an important point. This is a good argument where I said somebody said that the advocate's flogging a dead horse here, but the argument you've just said is that the manager could easily turn around and say, look, I made no assumptions about ethnicity. She may have married into that name and therefore she wouldn't have had any advantage. That wasn't the reason for my decision. It was purely to do with best person, best placed, and there was a business reason to move it. So you can always take one argument one way or the other. To deal with the point about flogging a dead horse, it's important that the advocate puts the employer's position to the advocate. If they don't, the judge will treat the evidence from the claimant as accepted. So it has to be challenged, even if it's not a good challenge. Sometimes you need to think about, okay, well, he's got the point across, is that this is yet another assumption. So it's a dangerous corridor to go down. You may end up in a corner, but he has to do that. So be aware that the advocate has to challenge certain things.
Yes, quite so, quite so. And what are thoughts on the chat in terms of how successful has the advocate been in being able to establish that this actually wasn't less favourable treatment at all? It was him playing the manager playing his best player, and it was an opportunity, don't you know? What's your thoughts?
My thoughts.
Let's see what the chat says first.
Yeah, okay.
Because you're biased, Stephen, you're the manager.
Yes, I was going to say, thanks for the invitation.
We'll hear from you in a minute.
Yes.
Think he's doing well is the thought that actually is this was as bad as she thought it was, interestingly. Wonderful. Thank you.
Can I just ask you, if you're thinking he's done well, think about what we're aiming for at the end here is the judgment and the submissions that Vicky has mentioned at the beginning. Just up down 2 or 3 points that make you feel that way. And conversely, if you're not convinced, jot the 2 or 3 points down as to why not, because that will become useful when we move through the session today.
Absolutely. Brilliant. So let's finish off then with the third section of the cross-examination, which is around the allegation of harassment. So the incident here, for those of you that have had a chance to look at this, is an allegation that Mr. Fletcher referred to Agnes wearing her Polish power outfit in the context of a meeting. Now, the point here on this one is that Mr. Fletcher's evidence is that he can't recall saying it. So in terms of dealing with this in cross-examination, going back to Stephen's point earlier, it has to be put to her that she may well be mistaken. But of course, that's quite difficult to say to a claimant who may be upset, clearly feels things quite personally, that she may be mistaken. So let's have a look at how you deal with that practically, and we'll see Chris in action for his third and final time.
If we move on then to the second allegation that you raise, you state that you were offended by his comment that you were wearing a Polish power outfit. Is that correct?
Yeah.
Now, I must say that I've never heard of a phrase like that. Have you heard of a phrase like that at all in the past?
Never before have I ever heard anything like that. And that's why I was so taken aback when he said it.
And despite having never heard of it, are you aware that it's a saying or a phrase that's used with any commonality?
Never heard that before.
Would you agree? And it's certainly my perception, that's a very unusual observation to make.
Yeah. It is an unusual observation to make. It's not something that I've ever heard anyone say to anyone before.
And before this, these issues arose, did you otherwise have a good relationship with Mr. Fletcher?
When I saw him, yes, it was fine. I didn't see an awful lot of him. He never really did, proper one-to-ones with me to see how I was or anything like that. It was very factual. It was just very information flow.
And you'll see from Mr. Fletcher's statement that in relation to the, let's call it the first part of your case, there seems to be a degree of agreement that, look, you were asked to carry out the task. He agrees that there were some reasons in relation to heritage that might have best placed you in relation to the task. But in relation to the second part, this allegation of the Polish power suit, he says, look, I deny that. Are you saying that Mr. Fletcher is lying by saying that he denied that?
He must be. He said it. I
Well, you
couldn't have
say
made
he
that
must
up.
be lying. He says that he didn't say it, and it's a very unusual phrase to say. Isn't there room here that you misheard it?
I don't believe so.
But is there a chance that you may have misheard things?
No. How do you misheard here? You've got your Polish power suit on.
And you don't invite any of your colleagues along to the tribunal to endorse having heard that either. You're not bringing anybody else with any evidence to corroborate that, are you?
No, because nobody wants to get involved. No one wants their career to be, to have any problems with James in the future. And I don't want to put them in that position.
Well, did you ask them, or is that another assumption on your behalf?
I haven't asked anybody because I didn't want to put them into that position.
So it is another assumption on your behalf. Thank you very much. I have no further questions for you.
Okay. So Stephen, talk us through why Chris has taken that particular approach with this cross-examination.
Yeah, so what we've got is a very clear witness who's adamant that something's been said. And what he's now done is he's linked that to yet another assumption. I think we saw on the chat, everybody saying, well, where's the evidence of this? And that's the crucial thing. So if you haven't got the documentary evidence, the next best thing is the witness statement, somebody coming along to back up what you're saying. And you'll see in the bundle, there's very limited evidence for either party here. But we talked about possession of a witness. There's nothing to stop claimants calling witnesses. Although they're your employees as employers, there's nothing to stop tactically the claimant getting the statement that they want and phrasing it in a way that they wish it to come across. So make sure that you speak to witnesses. If the employer wants to defend this, really the onus is upon them. They should bring witnesses that were present to say, I was there, I was 6 foot away, and I don't recall either hearing that statement or her raising the matter with me. So think about your witnesses. If you've not got the documents, goes to the witness statements and bring something to say, I didn't hear it.
Absolutely. So some really interesting points on the chat here as well. Confidential witness statements is a good question here, but of course the evidence this is a public forum. A real one is a public forum. So in that sense, the evidence would have to be given in public forum. And so the claimant's concern, if you like, about other people feeling uncomfortable about giving their evidence is a real point, isn't it? You can see why these concerns get raised.
I had a tribunal, it's a discrimination one, but that was exactly the claimant's evidence, in that she didn't want people to feel as if they were compromising their position of work. It's important to note 2 things from that. Confidentiality, even if it was given, if we dealt with this as a grievance, we can't guarantee confidentiality because these hearings are public. So that's the first thing to be clear on. The second thing is the law protects people from a detriment. And one of the protections they get is from what they call a protected act. But if you raise a claim of discrimination, or you are a witness to those proceedings, you are protected. So the excuse of not wishing to call somebody falls away straight away, because the judge will know that if there are any repercussions for any individuals, the law protects them. So it falls away and weakens the individual's position if you don't call that evidence.
Yeah, quite so. And as it appears, of course, Agnes did not give the employer the opportunity to investigate all of this internally. She just went to the hearing, went straight to the tribunal, obviously early conciliation first, but went straight to the tribunal process, which will be relevant if her claim is successful in terms of the compensation. So we'll have a look at that in a short while. Really interesting point, and so eagle-eyed on the part of one of our attendees here in terms of the evidence that she's given. It's changed from Polish power outfit to Polish power suit, and that may be relevant to the quality of her evidence. The judge needs to make this decision based on balance of probabilities. Is it more likely than not that these words were said, in order to be able to determine this question of fact at this point? Super. Let's, I think, take a well-earned break. And in that break, I'd really like you to have a further think about likelihood of success. So immediately after the break, I'll take another poll as to whether we think that the claimant is likely to win first the discrimination claim and then the harassment claim. Then we will go on and have a look at the respondents' evidence, and poor Stephen will have to have the joy of watching himself on telly, which is never great, I know. But you're taking it for the team today, aren't you?
Yeah,
Steve?
I'm afraid so, yes. Yeah.
Lovely. So shall we take, is it 9 minutes okay for everyone? So we'll take until 10 past. Let's stay in the call, I would suggest. We'll just pop ourselves on mute and turn our cameras off, but we'll stay in the call as well. We'll keep monitoring the chat. Stephen.
Can I just use that as an opportunity? At the beginning of CP and remote hearings, tribunals were disengaging and asking people to dial in. I would say 99% now, you'll be asked to switch your cameras and your mics off, but leave the connection on, which goes back to the point I made about the preparation. Make sure that you leave the room. Don't start ringing or texting people whilst you're in the same room. Leave the room. But do turn your mics off, do turn your cameras off, and it's good practice for the real thing.
Lovely. All right. So we will see you at 10 past.
Cheers.